Arriago, you filed suit. You said your vehicle was wrongfully towed. So why don't you give me some basic facts and information?
Everything started back in December of 2025. My vehicle was removed from Starbucks from Barton Springs. And when the defendant alleged that the reason for the removal was because I was not present in that Starbucks, I did try to provide the proof that I was, and the evidence that I did provide shows the receipts, the timestamp, and everything showing that I was present in at that store. Whenever I tried to request the evidence that they said they had once I went to retrieve my car that first time, they did not respond to my emails. They did not want to provide that evidence. And after the investigation that I did on my own, I concluded that I needed to submit my complaints, which at the time is the routes that I use for that. And so, because of this, I know the defendant is claiming that this was a fraud because I disputed the charge. I do believe that is an inaccurate accusation because when I talked to my financial institution, which was the bank, they asked me, "Do you recognize this transaction?" To which I answered, "Yes, I do. I made the payment on a duress, and so I need to dispute the charge." And it's not like the bank said, "Okay, we believe everything you say. We need you to provide evidence," which I did provide evidence to them. They did send that to their disputing department. I did have to wait a couple of days for them to process it. So there was a legal process for that dispute. After the bank reviewed all of that, they agreed that it was that they were going to dispute the charge, and so that's what happened with the initial tone. And then back in April 20th of this year, the car was again removed by the towing company. And so that is why I respectfully believed that this court does have the jurisdiction, because the case does involve my vehicle being removed by the towing company. It was stored in their storage facility. They did charge me fees to remove the car. I know the defendant is trying to categorize this as a repossession. However, I did not have any type of financial agreement with them prior to the removal of my car. My car was paid off 3 years ago in Ohio. They're not the lien holder. They're not my bank. I do not owe them any monthly payments or anything like that. What I did sign was a release condition that they told me that if I did not sign that, the car was not going to be released. And so that's what I signed there. I know they use the, I believe it's the Business and Commerce Code that they mentioned in that release invoice. It's my understanding after the research that I did that that code actually applies for secure creditor relationships, which I did not have with them prior to them removing my car. And so that's kind of what happened. Obviously, I'm happy to provide more details and with the evidence that I gave. But in addition to that, the invoice that they made me sign to release the car doesn't even categorize this as a repossession. It even has shows a towing fee of $1, but also the other itemization shows as other, which also does not match their fee schedule that they have published. And so for all of these reasons, I thought that the right thing to do was to submit this tow hearing.
I have a few questions, Mr. Arriago. Where is the car currently located?
It's currently at my where I live, which is the address that you probably have on file. So here in Southwest Austin.
When did you go get the car the second time from the towing company?
I got it. They took it the 20th, and I went the 21st of April in the morning. I don't remember the exact time, but it was around that time.
How much did you pay on April 21st to get your car out of tow?
They asked me to pay it in cash, $2,000 plus $25 of fees, so a total of $2,025 cash.
Okay. All right. Now you said that your car was originally towed from the Starbucks, and that was in December of 2025.
Correct, December 6th.
As a result of that towing, did you file a complaint with the tow hearing disputing that tow?
I started the process, so I filed a complaint with Texas Department of Licensing and Regulation. I also, yes, so I submitted one with the court. However, at the time, and this is the first time that I have to deal with a towing. So at the time, the knowledge that I had is that routes of communication that I was using at the time were going to be enough. So I didn't know that a tow hearing was going to be needed at the time. And so I didn't proceed with the tow hearing back then. I started it, but I didn't proceed with it.
But you did not file a tow hearing, you just filed complaints.
Correct, yes.
Okay. And then your car was towed on April 20th, and you received it back by going the next day on the 21st. You paid $2,025 and your car was returned to you.
Correct.
Okay. At the time you picked up your car in December, what day was that?
December 6th.
And when you paid, you said that you signed a release from them and
Yes.
that it had terms and conditions on it.
Yes.
Did you review those terms and conditions?
Yes, I reviewed the terms and conditions, and I did see the same code of business and commerce that is also present in the second invoice. Again, at the time I did the little research because I'm obviously I'm not a lawyer, so I had to do my own research, and so it's my understanding that again that code only applied to financial institutions or relationships between me and a secured creditor, which they're not. They're not a financial.
Mr. Arriago, I'm
Yeah.
gonna interrupt and just give you some information.
Mhm.
The tow company gets a lien interest in your property. So though they were not the company that you bought it from or took out a loan with, they are a secured creditor because your property is the collateral by which they secure their services.
Okay.
So it's no different than if you took your car for repair and the mechanic gets a mechanic's lien. They can repossess your car if you don't pay for the rebuilt engine or if you don't pay for the tires. If you get work done on your home and you don't pay for it, you get a lien placed against your title so that you can't sell your house until you finish paying for the air conditioning or the fence or the pool or whatever the work was done. In this regard, when the tow company is taking into the property they're releasing to you is a collateral. So that is typically what they're referring to in some of that. It does not matter that you did not borrow money from the tow company. That's where they get a special kind of lien against your personal property as a result of the type of work that they're in. And that is laid out by statute because that's not typical. Most people don't get a lien against property, but because of the nature of the work that they do, that's really the only way they have to make sure they ever get paid. Otherwise, literally every single person who got their car to tow could reverse the charge and then the tow company would never be paid. That's why the statute allows them for that type of redress.
That makes sense.
Just some information. Okay.
Thank you for clarifying. May I ask a question? Your
Absolutely.
Honor? And thank you for clarifying that. That's really helpful. Now, does that work when the tow in the first place was not, I guess, in my opinion, not appropriate due to the circumstances?
And Mr. Arriago, this is exactly why I asked you if you filed a complaint, because if you did not file a contested tow hearing, the law says that it can be assumed that the tow was proper because you did not pursue it in the method that's set out by statute. And the statutory method is for you to come to court like you're doing today. So I can't really look to whether or not you were properly towed back in Barton Creek. I would look to whether or not you complied with the agreement when it was released.
Okay.
Okay. All right. Any other questions, Mr. Arriago?
Not for now. Thank you.
All right. Anything else you wanted to share with me in the beginning? Because Mr. Flores gets to respond and then you get a chance to respond and ask questions again. But just right now, anything you automatically know, I want to make sure she hears that.
I don't believe so. Obviously, doing all this in my second language is kind of nerve-wracking, so I'm trying my best to make sure I'm following and understanding everything. But yeah, I just wanted to obviously express the situation, explain what happened, and yeah.
All right, Mr. Iger, you're doing wonderful. I 2 thumbs up.
Thank
All
you.
right then, Mr. Flores, good morning. Thank you. You're here on behalf of ATX Towing. I've gotten a sense of what happened. So plaintiff's car was towed one time. He got his car out of tow. It sounds like he reversed the charge and then his car was picked up again as a result of the reversal.
That is correct, Your Honor.
All right, go ahead, Mr. Flores. I know you had submitted a motion, so I'll let you explain some of that statute and the authority and what it is the defendant is seeking.
Yes, Your Honor. We're requesting that this case be dismissed. The original jurisdiction vested back in December 6th, or should have occurred within 14 days from the tow at that time, which he failed to perfect his ability to contest the tow at that time, and as such, his taking the law into his own hands by reversing the charge allowed my client to kick in his security interest in the possessed vehicle, which is written not only in the document itself that he was clearly aware of by 96608. If you would like for me to share a copy of that image, I'll be glad to. But I think you should already have a copy of that original release invoice. And it has it in that language, yes, albeit it's in small fine print, but it's still in there. And so I was actually, coincidentally, I was actually present on the night. It was a rainy night. My wife's car, on a side note, was stranded in the middle of nowhere. Mr. Montoya actually came to pick me up. I was in his car. I was actually on the phone when Mr. Arriaga called Mr. Montoya that night. And Mr. Montoya was very clear the whole time saying, this is not a regular tow. This is a repossession of your vehicle. So Mr. Arriago was aware that it was that the basis of the removal of the vehicle was based on a repossession interest that my client had as a result of not only the possessory lien, but also according to 9608, which was signed in that document. So for all these reasons, Your Honor, we believe that you can't relitigate something that's already happened. I'm not saying this court doesn't have jurisdiction to address anything below 20,000. I think it does, but I don't believe that this is the proper venue for hearing whether there was a viable tow or not, because this is not a question about a tow, it's a question about repossession. So we're asking the court to dismiss this claim, and yes.
Okay. And I agree, it's small print. I'm gonna share my screen. I wanna make sure I'm not giving any. I'm gonna put a big black box over where we would have had information related to your license plate number and your driver's license, okay, y'all? I'm not trying to share that live and on the world here. I'm also going to cover up a little bit of information about your car and the VIN number. Let me make sure I'm covering up all the really important stuff here. And yeah, no, I think this is actually the ATX's license number, but just in case, I'm going to cover that one up too. Not trying to get anybody in your numbers out there. Okay, now I'm going to share my screen, just this page, so we can all see what the release was. And this is the one in December. Right, hold on. Let me see. This is the one from December. And then there is another one. This one is the one in April. It appears to be. Actually, this one's a little bit cleaner. So let's go with that one because it's the one in April that we're actually here about. I'm going to cover up all that information again. Not trying to give out anyone's VIN number, license plate. Absolutely none of that. Yeah. Okay, I'm going to share my screen now, y'all. Again, I'm not trying to put anyone's VIN number, license plate numbers out there to the world. Okay. All right. Here's what I've got. So these were documents submitted by the plaintiff. So Mr. Arriago, you provided these documents to us, and you gave me a copy of your original tow receipt. This is the one from December, and then this is the one that we're actually, the dispute was filed within 14 days for this one. And so just information for parties. You both know this, but we get people who listen along sometimes. So tow hearings, you get 14 business days to do it. There's no dispute that this one was filed. This second one was filed correctly within that timeline. And on this one, and Mr. Flores, you're drawing my attention to the bottom of the page. At the top, it gives identification between the parties that indeed these things happened. And then, okay, making sure those boxes don't move when I scroll. Go back. At the bottom here, I'm going to zoom in because I want to see this information. Can I make this bigger? Okay. So, Mr. Arriago, this is your signature here as the release on April 20th?
Correct.
Okay. So I understand and certify that I am legally authorized to take possession. That's true. You own the vehicle. It's your car. ATX is not responsible for loss or damages by tires, bumper, brackets. No responsibility for loss or damage. So, if it got damaged, they're saying they don't have to pay you for that. Notice pursuant, I'm the person or agent acting on behalf of the person who's obligated to pay for the service. So I understand that I'm here and that I have to pay to ATX. I understand that the vehicle is subject to repossession in accordance with Business and Commerce Code 9.609 if payment for service is stopped or dishonored. So that's a major one right there. ATX appreciates your business. If you have any questions, please contact 512-400-8 and they give you the information. Here's Texas DRLI. Owner operator, which has been removed and placed in storage without consent, is entitled to a hearing on probable cause. Pursuant to occupations code, to do that, you've got to ask within 14 days after the day of the towing to the court, and then you got to come to the just fee. So they tell you how to come and file the suit with us, right? So they've given you that information. And particularly, Mr. Flores, that is this section right here that you're highlighting. That the payment was stopped or dishonored, and as a result, in accordance with Commerce Code, a defendant had the right to repossess the vehicle.
Correct, Your Honor. In addition to 7003, Well, in addition to possessory lien that most mechanics have as well.
Mhm. All right. All right, Mr. Arriago, anything further?
I was just wondering if I guess we can also evaluate the legal basis as to why they charged that amount, and also ask me to pay in cash for that amount that does not match their fee schedule.
Again, this is not a regular tow, Your Honor, so we are entitled to charge whatever we want for repossession of a vehicle due to, as long as it's done in a peaceable manner, and it was done in a peaceable manner since no one was there to oppose it. And so my client could charge $5,000 again if he wanted to for repossession, depending on the risk and everything. So that fee is commensurate with the risk that he took that night to make sure he got back the vehicle. The reason it was requested with cash is because clearly, again, there was a history of this person dishonoring his former method of payment. And so to ensure payment, we needed cash as a result of that, which he's entitled to request as a result of, again, his dishonored payment in the past. So we believe that the fees were necessary and reasonable at that time, especially that evening. It was a rainy evening, and I can personally attest to that, as I was stranded in the middle of the highway with my wife and her vehicle that night.
The original tow.
The original tow was December 6, 2025. I apologize. What are you asking about that?
Look, I pulled it up. You had already, plaintiff had already submitted it. The original fee for the tow was $337.44.
Correct.
Correct, but that's outside of this court's
Yeah,
jurisdiction.
I know. What did it cost originally, right? Because I'm coming up with what you're saying. Mr. Flores, I get what you're saying. So, Mr. Arriago, you asked about why they came up with the $2,000. And you're right, that's not related to anything. And that's because it is not one of it's not one of the license fees that's set out by statute. So the towing fee, the booting fee, the lift fee, the drop fee, like if you come up and they're towing your car and it's getting jacked up, you have the right to say, put it back down because you haven't finished securing it, and then you have to pay, it's called the drop fee, and it's a different fee than the full tow fee. All of those things are set out by statute. And the licensed operator, in this regard, ATX Towing, they are bound by that. So they don't get any discretion in that. The state said this is what we think is a reasonable fee to charge for those things. This is not one of those fees, because this is what Mr. Flores is saying, is that Mr. Montoya's company charged you a fee based on their own calculation of what it cost them to come and repossess the vehicle, the threat or the danger that might have presented to them as they came and did that. And Mr. Arriago, I want to highlight here, no one is saying that you were threatening or that it would have been dangerous, but in the nature of the business that Mr. Montoya's company is doing, yeah, that does bring with it some level of likelihood of a negative interaction at the time. It's no different than our constables who serve services for civil suits. There is some expectation, or at least a realization, that it could become not pleasant. And so that's factored into the price that they do. The other reason I'm asking, or that I was looking, Mr. Flores, is what was the original tow cost, right? So Mr. Montoya's company, or ATX, is out at a minimum the amount that should have been paid in December. And then for the months without it, they've not had those funds. And then they had to spend time and effort to go and correct that situation by taking back the car. So Mr. Flores giving me that is trying to assert that the $2,000 is reasonable in the context, given the work, the time, the effort, and the novelty of the situation that the defendant faced. And that is why it is not set out by statute. It would be, well, I would disagree. I appreciate counsel's zealous advocacy that they could charge any fee. Let's say Mr. Montoya asked you for $1 million. I'd say not possible, but how much is the car worth, right? So his lien is somewhat capped, but he is entitled to ask a reasonable fee. And I would also agree with Mr. Flores' assertion that ask you to pay cash was a necessary thing to do because the previous dishonoring of the charge, at that point he says, hey, and I see that a lot of times in leases that says, if you've dishonored once, now we only accept money order or cash going forward. All right. Let me just take a moment. I want to pull up the statute.
May I share one more piece of information, Your Honor? That
Absolutely,
I
Mr.
forgot
Flores,
to
go ahead.
mention that my client had to pay $500 towards arbitration for the credit card, the dispute. And so the credit card company made him pay $500 towards arbitration, which was not even found in his favor. And as you saw when in my response, I actually presented the tow receipt and also presented his credit card, that it was redacted, and I presented his driver's license to show that it was him, which he disputed, again, saying that it was under duress or whatever. But the point is my client was charged an additional $500, even though he lost that. So all these fees, again, contribute to the $2,000 charge, Your Honor.
Okay, and I'll just say that I am looking again at Business Commerce Section 9.609, and no, we want occupations code.
Well, for the security interest, I would request you look at 9609.
It's 9609. It's secured party's right to possession after default. So after default, secured party may take possession of the collateral. In this case, that would be the car. They can, without removal, render the equipment unusable or dispose of it. Here they did remove it, so they didn't, electronically disable the engine or put a stop on it of some sort. And these are some of the other examples I've seen. Under Section B, the secured party may proceed pursuant to judicial process or without judicial process if it proceeds without a breach of the peace. And I've not heard that there was a breach of the peace here. It was essentially a tow that was, an unfunded in the end, but nothing that caused any disruption. All right. Thank you very much. Then I really appreciate it. I've heard good information from both parties, certainly a sense of where the law is in the statute. So, Mr. Arriago, I'll give you some final information. And today it is going to be a plaintiff take nothing. And I'll explain why. You have the right to appeal. So in December, when your car was towed, per the statute and the Texas authority for that, if you wanted to dispute the towing from that Starbucks as being an improper tow, the single method allowed under Texas law is to file a complaint with the Justice Court within 14 business days of the tow occurring. And it's actually not of the tow occurring. It's of you either getting your car or being informed of your right to the hearing, which is why that receipt you gave you all that information. That is the tow company informing you of your opportunity, and therefore the clock begins to start running, okay? Because you did not file that complaint in December or within a timeline, I cannot now look back to see, was your car properly towed? The court must take it as true that it was properly towed. So then we turn to what happened after you got your car out. So when you went, you got your car, you did sign the release, and that release says that, by doing this, if you make no good on the payment, that does give the towing company a secured lien to come back and get the collateral, because the car is their collateral to make sure they get paid. Because once they have, then they don't have anything. So when you disputed the debt, and Mr. Montoya participated in that, and they found it against him, and I will also just say, Mr. Arriago, I'm trying to think of the correct way to explain this, or to make a statement here. Your credit card company found in your favor, but that is not a legally binding decision on the court. That's more of an administrative ruling, and how they came to that conclusion or that decision, any number of ways that could have been done. I would just say that while it might be nice to you that your credit card company found in your favor, ultimately it meant that you had not paid the bill to Mr. Montoya's company, and as a result, he did come and get back the security, which was by repossessing the vehicle again. So when he came and he got it out the second time, I don't find the $2,000 to be unreasonable or unrelated to twice having repossessed it. So even just basic $300 for those, he's at $600 in fees, plus he spent $500 arbitrating, and then he's time and effort to do all that. I think that's reasonable. So for all of those reasons, the court would find in favor of the defendant and say would be a plaintiff take nothing. All right. Again, all parties do have 10 days to appeal. No bond is required for that. All right. Thank you very much, everyone.
Thank you.
All parties are excused.
Thank you, Your Honor. Have a good day.
All right. Have a nice day. Have a nicer day, everyone. I know, not a lot of fun with these sometimes. Thank y'all.